did? Oh, your dad mom. I couldn't believe you wouldn't remember.
I mean, when you put forth a philosophy or ideology or theory, the minimum you should do is apply it equally.
I agree. My argument was equally fair. I mean, for my end.
After lunch, you want to have my seat?
I know.
I'm going to wait until
You know.
Give me consistency at least.
Well, though, yeah.
Because applying that theory.
No. Oh, you're going to see.
Let's hope.
Oh, yeah, I could say yeah.
Enjoy your vacation.
I'm shocked to hear a few times. Usually pretty good at knowing how. I mean, I didn't real clear there. She goes around there again. And that's what she used. I didn't like the way he, on the one dad who...
How old is he? I have and a grandson.
Yeah. You do not have a grandson. You do not?
kind of came to that conclusion.
Yeah, it's impossible. 21, 17.
He's going to try again.
I thought you
He just beats other kids. He doesn't beat it. I mean, that's kind of what I was.
I come over again.
I didn't know
Fine,
that.
now you are. You going to
Move around.
I'm going to try to keep myself.
How much gesticulation?
Well, it's a crowded place, so I won't. I'll be mostly.
I thought you ruled this one.
Thank you.
Put it up here. Put it on the shelf. If it drops, then...
Why don't you just, John, why don't you just hold it and follow it?
I'll work down the
Miss Vicky, you want to tape it on there?
John, why don't you just hold it and follow her around?
I'll try not to.
Well, yeah, Nate, let me just...
You said it was?
I can't move that fast. She might tear it. We're in the glory.
Right. That way it don't fall.
I wish my phone wasn't going good. I can show you my grandbaby.
Thank you.
7 months.
Oh, yeah.
So precious.
Yeah, you did know this part.
Not much. Well, usually I don't write.
I like listening.
Huh?
I like listening.
Okay, we're back on the record in the matter of the Blair Berry children. Ms. Burns, do you have a chance to speak to the mother?
No, Your Honor. I just wanted to hear for the closing.
You could.
Thank you, Your Honor. Thank you for allowing me to do this now as opposed to trying to wait till after lunch. One of the things that I just wanted to address the court is, you know, we all need to get back to what the purpose of this court is, and this is the Child Welfare Court. Now, it may appear that I talk out the both sides of my mouth or that there's some type of duality, but what we are charged with in this court is dealing with the entire family, the totality of the family. In this case, Your Honor, the totality of the family is not just Ms. Mitchelle Blair. It is also Mr. Dorsey and Mr. Bear and the 4 children that they together brought into this world. Now, I would agree with the Assistant Attorney General. Based upon my client jurisdiction, I have no argument. I would wholly disagree with counsel for the fathers that jurisdiction in this case with regard to Mr. Blair and Mr. Dorsey does not exist. Why? Because we blame it on someone else? Just taking last in turn, Ms. Anderson, with regard to Mr. Dorsey, no, I'm sorry, with regard to Mr. Berry, well, I was in jail, I didn't know. Well, before he went to jail, one of her time periods, let's take that. We go back to 2005 where she says, well, I don't know, he didn't know there was anything going on. Well, the exhibits put forth by the Department of Social Services, I'm not sure which exhibit number it is, Your Honor, but it's the DCH 154, which deals with the entire history of the protective services in this case. And we have the history of the 2006 case. One of the things when the court is reviewing that, Mr. Berry was living with Ms. Blair at the time. He didn't know about the abuse to the other children, but they were living together. They were living together when that document says Ms. Blair was going through in-home services. He was in the home, he knew what was going on in the home. Jump forward, I would say, contra to counsel, that doesn't make him omnipotent as to what goes on later. What it does is put him on notice. The fact that he now says, well, I visited with Matthew regularly. He visited with Matthew regularly, yet he never noticed, and from the kid speak, Matthew, I'll take what his words just as she did. He testified in kid speak that his constant companion was his sister Gabrielle. So if Mr. Berry was there, Gabrielle was there. And unfortunately, if Mr. Blair was there and Mr. Berry was there and Matthew was there and Gabrielle was there, what happens or what are we to do with all the testimony presented in the documents that Gabrielle had knots all over her head? Did that put him on notice for anything? Obviously not. We now can only blame 2005 Department of Social Services. The blame for the deaths of her children, Ms. Blair has already accepted. The blame for the treatment of her children, we've presented no testimony with regards. But if we go back to the totality of the family, Mr. Berry said, well, I tried to work and I paid by food, etc. And the witnesses they called, that was only out of his mouth. But what did he do with the friend of the court? He paid nothing. Those documents, rather than the argument of counsel, rather than the statements of Mr. Berry, those documents from the friend of the court have been presented into evidence. He paid nothing. I agree with the Assistant Attorney General. Mr. Berry is well aware of the court system. He wants to use that as a shield for not accepting any parental responsibilities. If, as counsel puts forth, he didn't do an abatement because he was in prison, what happened when he got out? Friend of the court is still there. The amount of arrearages in the friend of the court for when he was in prison are still there. Has he gone to the friend of the court to say, well, I was in prison, cut down some of my arrearages? Or guess what? Even more importantly, I knew something was going on back in 2006, and then I went to jail, and now I can't visit with my children. Court, can you assist me? Doesn't cost a thing. Did he go? No. But Mitchelle Blair and the Department of Social Services are the only ones implicated in not taking care of this family. Now, jurisdiction, Judge, one thing everyone, again, tends to not focus on in this court, and it has always been for the 32 years that I've practiced down here, jurisdiction is not with regard to the parents, what they did or didn't do. Jurisdiction, and I will call the court in re CR 2001 case that has never been changed or amended. Jurisdiction is tied to the children. What happened to them? Court has jurisdiction completely and totally in this case. In terms of Mr. Dorsey, he blames the Department of Social Services also. He says, well, in 2005, my sister, and he says it from the stand with honor, which he should. My sister called the Department of Social Services because we noticed marks on the backs of my children. Okay. The document, the DHS 154, he says he wants to establish parenting time with his children and form a better relationship. That's the only thing he says in that. But in that report, he does nothing to further that. Outside of that report, he does nothing to move forward with that. He too, I visit regularly, I was there, I just met Mitchelle Blair, she's such a what did counsel say, had an atmosphere of control. Judge, you've been here, she can't control herself, how can she control anyone else? And what did he do? Nothing, because it was easy. Now, none of this excuses Ms. Blair, but what it does, and I guess I go back to hindsight is 20/20 because everyone seems to be wanting to go to the past. What if Mr. Blair and, Mr. Dorsey and Mr. Berry had been there? What if Ms. Blair found out that her older children were abusing her youngest child? What if they were there and she had some support? What if she was there and she had someone to talk to and ask for what her options were? What if you have a person who has been abused herself in the past and now who is taking care of 4 children and has all this going on and somehow snapped? What if she had people who were saying, hang on, we'll help you deal with this? That is also implicit with regard to the fathers here. It doesn't excuse Ms. Blair, but it says, what if? What if there was something, a safety net to catch her, to catch these children? Jurisdiction is about the children, not about the parents. Excuses, well, Judge, my client hasn't made any excuses. She says a lot about, we all heard on the news, etc., do it again, do whatever. I don't think that could have happened if there were more supports. But that doesn't take this court's jurisdiction away from Gabrielle and from Matthew. I would agree wholeheartedly with each and every statutory basis that the Assistant Attorney General brought forth with this court with regard to the statutory basis for termination. There is and has been shown a preponderance of evidence for jurisdiction. It would be inconceivable in the 32 years I've been down here for this court not to take jurisdiction on everything that's been brought forth before this court with regard to all the parties. The one thing, and we'll get to it in terms of looking at the children, is what is the next step. Looking at the children in the condition that they are now, where do we go? The children are with a relative and they finally have stability for the first time in their lives. best interest, and that's where they go. That's where they stay. What happens in terms of what the fathers have done in the past for the future? We have children who need extraordinary care. Haven't heard a word from any of the fathers what extraordinary care they would provide. Not a single word, just that it's someone else's fault. Well, the deaths, unfortunately, are someone else's fault. But the neglect and the atmosphere and the totality of this family, they are intimately involved with. Thank you.
You have rebuttal, Ms.
I do have rebuttal.
Approximately how long do you?
Less than 10 minutes?
Then we'll come back after lunch for decision.
Judge, I want to actually continue with something that Ms. Burns was saying. There was discussion, at least by one of the parents, one of the father's attorneys, about the fundamental rights of the parents. And as Ms. Burns stated, what about the fundamental rights of these children? The fundamental rights of Gabrielle Blair and Matthew Berry to live in a fit home or environment. To wake up every morning, as their fathers did, after Mr. Berry's release, if you want to go with that time period, as Mr. Dorsey did, to wake up every morning and not be in a household where you are constantly faced with the fact that two of your siblings have been murdered. You wake up every morning after 2012 and you have a sibling in a freezer. And then another sibling. While these two men are waking up in their own homes without a care in the world. Oh, I'm sorry, they couldn't get a job. These children are waking up with two dead siblings in their homes because these men did not care enough to find out, to get involved in their children's lives. It's that simple. This does not come back to the Department of Health and Human Services from a 2005 case. It does not. And counsel wants to use the word incredulous. Well, that argument is incredulous. To say that over 10 years ago, that these children's lives, their deaths, are the department share some responsibility? No, 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 no. The only people who have responsibility to these children were their mother and their fathers. And you have two fathers who didn't even know their own child was dead. Didn't even know that. Didn't care to know enough to find out to say, can I see his face? Can I see her face? That's what's incredulous. These children woke up every morning not knowing what their mother was going to do that day. Beaten themselves, traumatized themselves. And the court, Ms. Burns is right, the court has medical records that state that Gabby had a broken tooth. There were marks on her body, on her forehead, a scar that an interviewer, that the medical doctors, nurses were able to examine. Had these men done a little bit more than, with respect to Mr. Dorsey, knock, 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 oh, here's my little porch visit. And the last time Mr. Dorsey states he saw, or at least spoke to, Gabby, was in 2014. Whether it was November or December, that's beyond the 91 days. Ms. Anderson claims that her client was regularly visiting his children after his release. Well, that's not what he testified to. That's not what's in that 154 either. When he was first questioned by DHS, and Ms. Hayden testified this, he indicated Mr. Berry did the last time he saw his children was in 2010. He then changes it to 2012, which we now know was 2013, but obviously that's well in excess of 91 days. These fathers want to pass the buck. It's not acceptable. They should feel guilt. They should feel blame because they are culpable. Find that $1.75. Take some cans back. Use some of the money you're using for your cigarettes. Take that bus and see your child. Demand to see your child. They couldn't be bothered. They didn't want to be bothered. And now they're standing before this court saying, don't terminate my rights. Come on. Care enough to find out that your child is actually living or dead. Had they done that with respect to Gabby and Matthew, had they demanded to see their children, had they actually gone to see their children, they could have talked to their children more. The responsibility is not on these kids to disclose. It's on their fathers to be involved in their lives enough to ask questions, to look at things, to find that, hey, why are my kids always wearing long sleeve shirts in the summer? To see that those things are a little bit unusual, and there might be something behind that. Acts of omission are just the same as acts of commission. The only 4 people who are blameless, innocent, the only 4, not 1, not 2, not 3, not 4, are the Blairberry children. I submit to this court, as I previously did, that all of the statutory grounds in regards to termination have been met with respect to Mitchelle Blair, Alexander Dorsey, and Stephen Berry.
Okay, thank you, Ms. Megacy. So we will take our lunch break now. It's about 5 minutes to 1, and we'll come back at 2 o'clock.